See, which fell for our consideration, having regard to your submission, is whether the explanations appended to Rule 38 of the 2016, 5 of the MC 2017 respectively, and in consequence of violation of Article 14 of the Constitution. This is the question we have addressed. We have, while examining the challenge to the validity of laws related to economic activities, the court and circumspect of deference in such matters, sufficient flexibility should be given to and the executive in dealing with economic matters. Issues of economic and cannot be construed by a check-it formula or unidirectional approach. This court has recognized that a judicial hands-off followed qua economic legislation, and that the legislature is to be allowed wide latitude in experimenting with economic by virtue of it being an government's economic policy. Since the MMDR thereunder pertain to the extraction, disposal, and sale of natural resources, which is a policy that entails intricate economic choices and have a direct macro, we are of the considered opinion that when it comes to computation of royalty, the legislature play in the joints. The exclusion of royalty and contributions towards it previously for coal, but minerals may not be termed as arbitrary or unreasonable merely because the computation for one differs from the other in certain aspects. Deference needs to be legislature in deciding how royalty must be computed in respect of different concentrates. The present, more particularly the challenge to Rule 38 of the MC 16 and Rule 40 CDR 2000 in its own way. While there is nothing to show that such access of the powers or domain of or in breach of any statutory provision at the ignore or that the legislature itself anomaly in compounding of royalty for the purpose of computation of. Similarly, to exclude previously paid royalty and coal, but not for other minerals, approach in a rigid manner, yet it would be incorrect framed and tailored by the particular subject blanketly applied to other areas. Executive, which is best suited to distinctions existing or seemingly similar domains, formulate distinct similarities. Even in the respondents herein appear to have acknowledged mechanism for computation of coal and other minerals is not based on a fine distinction between the two, but rather an anomaly in 2016, and is why it constituted a committee to look into the same and amendments for rectifying the same. View of the fact that the appropriate authority considering in the computation price for all other minerals, and the fact that the notice for public on amending the MMDR Act addressed the aforementioned issue, say anything further whether the explanations 16 and Rule 40 CDR 2017 arbitrary or not. the computation of royalty for is purely a matter of policy, not shut our eyes to the prima facie anomaly that exists both in the very computation of average sale price for minerals in terms of the aforesaid provisions and the stance of exclusion of only coal from such mechanisms of general nature and application of the aforesaid rules. I intend to grant one last opportunity to the respondents herein to consider the mechanism of computation of average sale for the purposes of determining the rate of royalty for all other minerals in terms of the explanations to Rule 38 of the MCR 16 and Rule 45 of the MCDR 2017. We direct the respondents to conclude the process of public consultation in respect of the compounding of royalties and take a well-meaning decision keeping in mind the representations made by the petitioners here. Remind the respondents that it cannot be the aforesaid issue in limbo on the pretext of ongoing process of public consultation process. Yes. So we have granted, just a minute. Prepared Suvira. Now, aforesaid we grant pronouncement of this judgment through the public consultation process undertaken for amending act initiated to the notice dated 25th of decisive call in regard to the cascading impact of royalty on royalty in the average sale price by virtue of the explanations to Rule 38 of the MCR 2000.
Hear the judgment till the end. There was a pause and there was a however. Teaches us that, however. Tell you what to do after this.
Assistance. Thank you very much.
Deeply obliged.
Thank you to all my law clerks also, relentlessly work.
Of course, above all, but it's very.
Who appeared in this matter?
Yes, I am.
You appeared. Having heard the learned counsel appearing for the parties and having gone through the materials on record, a short question that falls for our consideration is whether we should reference under section time bound. Yes. The existence of the arbitration agreement as contained in 3.10 of the shareholders agreement is not disputed by either of the parties. The submissions as regard the claim of the petitioner being ex facie time barred may be upon by the arbitral tribunal as a preliminary issue. Aforesaid, the present petition is allowed, taking into consideration the fact that an arbitral comprising of a sole arbitrator, Mr. Mayur Khandeparkar, Advocate High Court at Bombay, has already been constituted for the adjudication between the same parties. The service agreement would be desirable to constitute an tribunal comprising of the same for adjudication of the present disputes pertaining to the shareholders dated 25th of July 2000. The fees of the arbitrator, including other modalities, shall be fixed in consultation with the parties. This is how we have allowed it.
There's only one development. The learned arbitrator has returned back the matter. It's saying for one of the parties. So I'll file a suitable application, Milords, or
Mr. Mayur.
yes, just a few weeks back, he's returned it. He's saying that he's appeared because they had taken an objection. So matters, even in that matter, Milords.
Ask a separate card. We can then, you are appealing for the other side, right?
Yes.
If Mr. Mayur Khandipar has said no, we can separately.
Vishal Kanade, subject to your lordships or any other name.
The judgment is pronounced. Counsel appearing for the petitioner over notice that Mr. Khandeparkar has shown his disinclination to act as the arbitral tribunal.
You have a letter he's communicating.
He has in fact passed an order.
All right.
Then they informed him that
All
it
right.
appeared for them. That's why.
In such circumstances, we appoint
Vishal Kanade,
Kanade, advocate, High Court of Bombay, as the arbitrator, sole arbitrator. Right?
So that matter I'll file.
That matter you'll have to take out
Yes,
an application.
yes.
Yes, I
understand. Do that, Milords, but then.
Your Lordship, I'm really sorry, but would it not be an application so I can seek instructions on the suggested name?
That's all right. I mean,
Because they were to move. What happened?
you have appointed the same arbitrator.
1504.
Obliged. Highly.
You appeared for the petitioner. We heard the learned counsel appearing for the parties and having gone through the materials on record, the following law fall for our consideration. 1. Whether the present petition under section 1996 is maintainable. 2. Whether part 1 of 1996 is applicable to the contained in the distributor dated 9. 3. What is the terms of the distributorship agreement 2010? So these are the 3. This is UAE matter, courts in Dubai. Our conclusion is position of law, the law emerges. The Act 1996 and the only applies. Arbitration takes place in India, where either 1, the seat of arbitration is in India, or the law governing the arbitration agreements are the laws of India. Arbitration agreements executed after 6 September 2012, where the seat of arbitration is outside India, Part 1 of the Act 1996 and the provisions thereunder will not and would fall beyond the jurisdiction. 3. Even those arbitration agreements that have been executed prior to 6 September 2012, Part 1 of the Act 1996 will not be applicable. Its application has been excluded by the parties in the arbitration agreement, either explicitly by designating arbitration outside India or implicitly by the agreement to be any other law other than Indian law. 4. The moment sit is determined, it would be a exclusive jurisdiction clause, whereby only the jurisdictional courts of that seat alone will have the jurisdiction to regulate the arbitral proceedings. The notional doctrine of concurrent jurisdiction has been expressed and overruled by this court in its subsequent decisions. 5. The closest connection test for determining arbitration by identifying the law with which the agreement to arbitrate has its most real connection is no longer a viable criteria for determination of the seat or situs of arbitration in view of the Sashao principle. Seat of arbitration cannot be determined by formulaic and unconditional of choice of law rules based on abstract connecting line contract. Even if the law governing the contract has been expressly stipulated, it does not mean that the law arbitration agreement and by extension the seat of arbitration as the lex contractus. 6. The more appropriate criterion for determining arbitration in view of the subsequent decisions of this court is an arbitration agreement, there is an express designation of a place of arbitration and proceedings to such place, and there being no other significant contrary to show otherwise, such place would be the seat of arbitration, even if it is designated nature of venue in the arbitration agreement. 7. Where the use of a particular place or supranational body of rules has been stipulated in an arbitration agreement or clause, such stipulation is a positive indicium that the place so designated is actually the seat as more law governing the arbitration agreement, and by extension the seat of the arbitration tends to coincide with the curial law. Merely because the parties have stipulated a venue without any express choice of a seat cannot sideline the specific choices made by the parties in the arbitration agreement by imputing these stipulations as at the behest of the parties as regards the seat of arbitration. Deference has to be shown to each and every choice and stipulations. After all, the courts are only a arbitration is derived from the choices of the parties and their intentions contained in the arbitration. It is a duty to wait and due consideration to each choice made by the parties and to construe agreement in a manner that aligns the most with such stipulations and intentions. We do not for a moment say that the closest connection test has no whatsoever, where there is no express or implied designation of a place of arbitration in the either in the form of venue or curial law. There, the closest connection test may be more for determining the seat of arbitration. 10. Where two or more places that have been designated in the arbitration agreement, either expressly or impliedly, equally appear to be the seat of arbitration, then in such case, conflict may be resolved through recourse to the doctrine of forum non-convenience, and the seat be then determined based on which one of the possible the most appropriate forum, keeping in mind the nature of the agreement, the dispute at hand, the parties themselves and their intentions, the place most suited of all the parties, and the ends of justice may be determined as the seat of arbitration. Thus, for all the foregoing reasons, the conclusion that the present petition under Section 11 of the Act 1996 is not maintainable, as neither the seat of arbitration is in India, nor is the arbitration agreement governed by law. In the result, the present petition filed by the petitioner fails and is hereby dismissed. So, For HPCL?
Yes,
Yes.
The argument of the other side, the petitioner, was the application under Section 11 filed before the Bombay High Court was not maintainable because it was a fresh application filed. Your client, having filed unconditional, takes recourse to the IBC proceedings up to this court in the IBC. You went to court, filed a fresh application. Therefore, in this background, we have addressed ourselves to three questions. One, application under Section 11, subsection 6 of the Act 6 filed by the respondent could be said to be maintainable when no liberty to file a fresh application was granted by the High Court at the time of withdrawal application under Section 11(6) of the Act 1996. 2. Application under Section 11(6) of the Act 1996 filed by the respondent on 9th December 2020 could be said to be time-bound. If yes, whether the respondent is entitled to the benefit 14 of the Limitation Act. In other words, whether the period spent by the respondent in pursuing proceedings under the IBC is liable to be excluded while computing the limitation period for filing the application under 6. And 3. Whether the delay caused by the respondent in filing the fresh application under of 1996 can be condoned under Section 5 of the Limitation Act. Our judgment proceeds on the footing that your fresh application was not maintainable, applying the provisions of Order 23 of the CPC. We have gone ahead in saying, assuming for the moment that it was maintainable, it was time, and 14.2 would not save because it cannot be said to be for the same relief. IBC proceedings differ from the arbitration proceedings. So all three issues we have decided, and our final conclusion is, in view of the aforesaid discussion, we have reached to the following conclusion. In the absence of any liberty being granted at the time of withdrawal of the first application under Section 11(6) of the Act 1996, the fresh application filed by the respondent provision was not maintainable. 2. The fresh application filed by the respondent under Section 11 of the Act 1996 was time. 3. The respondent is not entitled to the benefit of Section 14, subsection 2 of the limitation. The respondent is also not entitled to the benefit of condonation of delay under Section 5 of the limitation. In such circumstances, we have set aside the judgment of the Bombay. The appeal is allowed accordingly.
Gratefully, Your Honor.
This little eye-opener has taught one and all many lessons so far as IB and the functioning of the NCLT, NCLA. But given due consideration to all the submissions, canvas, Mr. Venkatraman's submissions, Mr. Shankar Narayan and your submissions, Mr. Roh's submissions, and the matter threadbare. Having regard to the issues that fell for our consideration, we have to three questions. One, performance bank guarantee could have been adjusted against the first tranche payment, which was to be made under the resolution plan within 180 days date, in contravention of the order of this court dated 2024, the terms of the resolution plan and the provisions of law. To put it in other words, whether the impugned order of the NCLAT adjustment of the performance bank guarantee in lieu of payment of the first tranche could be said to be perverse. 2. Implementation of the resolution plan by the SRA necessarily leads to the consequence as provided under section 3 of the IBC. And 3. Whether the timely implementation of the plan is also one of the objectives of the IBC 2000. The objection was raised on behalf of the SRA that the Section 62 of 2016 restricted to a question of law. In our considered view, order of the NCLAT directing the SRA to adjust rupees 150 crore against tranche payment of rupees 350 crore was in flagrant disregard of the order of this court dated February 18, 2023. The term plan. Such an order was perverse for properly considered several material facts and misreading the record. Furthermore, the non-payment of funds in compliance with the applicable laws and the resolution plan led to circumstances causing a failure of the resolution. We have no doubt in our ability acted to settle legal principles and went to the extent of drawing wrong from proved facts in the matter. It justifies the examination issues in exercise of afforded Section 62 2006. Overruled the preliminary objection that there is no substantial question of law involved in this appeal. On the first issue, we have concluded that the performance bank guarantee 150 crore could not have been the first tranche payment of rupees 3, which was to be made by the SRA, since the same is in flagrant order dated 18 January 2024, the terms of the resolution provisions of law. The PBG could not have been allowed the terms of the request for resolution, specifically clause 3.2, 3.8, and 3.13.9 respectively, which on the SRA through clauses 7.3 and 9.4 respectively of the resolution plan. The RFRP is clear in its intention that the PBG shall not be used as a part of the consideration that was to be given by the SRA under the plan. 5. Allowing such an adjustment was also in direct violation of regulation B 4 IBBI, Insolvency Resolution Process for Corporate Persons, Regulations 2016. According to 36B 4 A, the PBG furnished by the SRA would be liable to be forfeited if it fails to implement or contributes to the failure of implementation of the resolution plan. Therefore, the PBG live until the completion of the implementation of the resolution plan. 6. The contention of the SRA that the adjustment of the PBG towards payment was only impossible under the terms of the lenders dated 16th of August 2023 and was permissible of the resolution plan must be rejected. This is because once the resolution is approved by the adjudicating authority under subsection 1 of the IBC, it was made binding on all the stakeholders and was immune to any modification. The lender's affidavit could not have imposed conditions which were different from those provided in the plans. This is the contract dated 18 January 2024 directing an infusion of rupees 150 crore made. Such an infusion in cash was required in the lender's affidavit and the terms of the resolution plan as well. NCLAT incorrectly interpreted our order. Were restricted under the lender's affidavit only. The impugned order incorrectly allowed the adjustment of the PBG of rupees 150 crore against the first tranche, directly violating the direction of this court, the terms of the resolution plan, and the provisions of law. On the second issue, we have arrived finding that the SRA failed to implement the resolution plan by not infusing the first tranche payment of rupees 350 crore as required by clause 6.3.1 bracket small g and the implementation schedule under clause 7.7 plan. The SRA, by not infusing the first tranche payment as per the terms of the resolution plan, on its obligation towards the payment of CIRP costs, which include airport dues under clause 6.4.1 of the resolution. 9. The SRA not having infused the first tranche payment as per the terms of the resolution plan could also be clause 6.4.2 of the resolution plan, which required a minimum liquidation value to the workmen and employees as well. Moreover, both the Provident Fund and gratuity dues, 226 crores, should also have been paid by the SRA in accordance with the order dated 21st 2022 of the NCLAT of its obligations, which it failed to do. 10. Therefore, there was NCLAT grounds now that the within the terms of the plan and the cost therefore be directed as per section 33 subsection 3 of the IBC 2000. On a coordinate delay, implementation of the resolution plan, the CIRP costs of the cost are continuously multiplied. Students are incurring huge expenditure each month towards corporate data. The fundamental of this court must not only be of essential and complete justice, but also to ensure expeditious resolution of the issues in the interests of the underlying IBC and all the stakeholders involved. We must obviate the possibility of the corporate embroiled and its resolution being further delayed, especially in light of the delay that issue. Having due regard to the materials on record, a determination that the terms of the resolution have been contravened and that there has been a failure to implement on part of the SRA on a consideration of the issues before us. As SAN is no longer key, we must ensure for the corporate debtor and its creditors. Being mindful of the that time and speed are of the essence under the code, and to prevent the frustration of this objective, we are necessary to exercise our plenary powers under Article 142 and direct a corporate debtor in the manner as laid in the IBC. Granting this relief to the appellants would not run counter to the timelines and that is central to IBC. On the contrary, it would be in furtherance of it, ensuring that liquidation commences as soon would also be in the best interest of the corporate debtor and the creditors, including the workmen, employees who are yet to receive their rightful dues. We has also given us an opportunity to suggest few things. It is for the parliament, but the suggestions are important on varied aspects of the matter. Our final conclusion is like as a result, the appeals succeed and are allowed. The impugned order passed by the NCLA in the peculiar and alarming circumstances as discussed in this judgment, and also keeping in mind the fact that 5 years have elapsed since the resolution plan was duly approved by the NCLAT, and there being no progress worth the name, no other option but to invoke our jurisdiction under Article 142 of the Constitution and direct corporate debt to be taken in liquidation. The NCLT Mumbai shall now take appropriate steps for appointment of liquidator and all other necessary formalities of liquidation of the corporate debtor. The amount of rupees 200 crore already infused by the SRA stands forfeited. The lenders, creditors are further permitted to encash the performance bank rupees 150 crore furnished by the SRA. We accordingly, these appeals are disposed of in the aforesaid terms.
Incidental issue. My lord, there are a series of cases. Erstwhile resolution professional note one application because of this delay. My lord, we are now how fora across was praying for some immunity, my lord, to the resolution professional because many cases, my lord, the RP ends up being the. But my application is 230101.
We'll have to look into independently.
That can be listed.
For the present, this is our.
Lordship,
So, Mr. Venkatraman, thank you very much for your valuable assistance. Mr. Shankar Narayan, thank you very much.
Grateful.
Thankful to my law clerks also, assisted me
Big learning curve.
brilliantly.
May I pray for early listing of my application at your lordship's convenience. 23010. Well, I'll do that. I'm grateful.
This is a short matter. Who appeared? We have appointed Mr. Asif Dar, former Chief Justice of the Punjab and Haryana High Court, as the sole arbitrator to adjudicate the dispute between.
My learned brother thanked all of you. Thank him because I must. If I don't think he has slept for the last 3 or 4 nights. Working around the clock. Ready because
With my entire team.
Fortunate they have to have learned so much.
This is a nostalgic moment for me, Mr. Venkatraman. This is the last judgment I am pronouncing with my Lord the Chief Justice by me. Otherwise, we have few judgments
which will be pronounced tomorrow.
But these are all judgments which I had the honor of with the able of my Lord the Chief Justice and my learned brother Justice. So that is nostalgic about this. And right? Having counsel appearing for the parties and having on record, following questions call for our consideration. 1. whether there is an error apparent on the for the purpose of entertaining the review petition. 2. If the answer to the question is in the affirmative, then whether the exposition of law propounded by this court in as regards the power of the DRI to issue show would be said to be the correct statement of law. This would be of the following questions. A. Whether officers of DRI are the proper officers of Section 28 of the Act 1962. B. What would be the extent, scope of Section 6 of the Act 1962 vis-a-vis Section 2, subsection Section 3, Section 4, and Section 5 of the 62, and whether an entrustment by the central government under Section 6 of the Act 1963 to empower the officers of the DRI for the issuing show cause notices. C. Whether the power under Section 20 is exercised only by someone who is empowered to exercise the power under Section 17 of the Act 1962. In other words, how best the meaning of the expression should be construed for the purposes of exercise of function under Section 28. D. Whether the power in Section 28 must necessarily be the same referred to under Section 17 of the Act 1962 if the use of the definite article the in the proper officer in Section 28 is in the context of that proper officer who has been assigned the powers of discharging the function of Section 28 by virtue of powers conferred under Section 5 of the Act 1962. Whether issuance of show cause notices followed by adjudication under Section 28 1962 is an administrative review or a quasi-judicial exercise of power under administrative law. Whether the introduction of Section 28, subsection 11, the Validation Act of 2011, which retrospectively validates the show cause notices issued under Section with effect from 6/7/2011 is discriminatory and arbitrary during the defect highlighted in Syed Ali and therefore is violative of Article 14 of the Constitution of India. Judgment delivered by the High Court of Delhi in the case of Mangli Impact expounds the correct interpretation of Section 28 subsection and whether Section 97 Act 2022, which retrospectively validates the show cause notices with effect from 140 is manifestly arbitrary and therefore violative of Article 14 of the Constitution of India. These are the issues which I'm highlighting. Section read with sections 46 and 47 of the Act 1962 respectively deals with and reassessment at the first instance, that is, upon entry of the consignments and clearance of bills of entry. The amendment to section uses the process of self-assessment and subsequent reassessment upon verification by the proper officer for undertaking a check at the first instance. Section 28 are subsequent to the completion of out in Section 17 of the Act 1962. The procedure envisaged under Section 28 is in the nature of judicial proceeding with the issuance of the show cause notice by the proper officer, followed by of such notices by the field customs officers. Noting that in the case of DRI, the proceedings under Section start only after an investigation has been undertaken by DRI. This is Circular number 4 of 1999, dated 15th of February 1999, and Circular number 44 of 2011, dated November 2011. Therefore, the nature of review under Section 28 is different from the nature of assessment and reassessment under Section 17. The 28 has also been restricted to the review of assessments and reassessments done under Section 17. For asset, there has been a short levy, part payment, non-payment, or erroneous refund. Statutory scheme in mind, we are unable to subscribe to the view taken in both Syed Ali and that the vesting of the function and reassessment under Section 17 is a threshold mandatory condition for a proper officer to perform functions under Section 20. This is an error apparent on the face of the record. This scheme does not flow from the scheme of the statute, read in to avoid the possibility of chaos and confusion, potential for multiple proper officers exercising jurisdiction under Section 28. Find that such apprehensions of misuse are unfounded, considering that no substantial empirical evidence has been brought forth in this case to support such a view. Regardless, the parameters under Section 28 cannot be reduced to an administrative review of assessment, reassessment done under Section 7. We are conscious of the fact that Section 110AA of the Act 1962 introduced by the Finance Act 2022 stipulates notice under Section 28 of the Act can only be issued by that proper officer who has been conferred with the jurisdiction of functions under Section 5 of the Act 1962 to conduct assessment under the Act in respect of such duty. However, we are of the view that the introduction of NAA doesn't alter the statutory scheme of Section 8 of the Act 1962 as it stood prior to the introduction of Section 110. The legislature, in its wisdom, may introduce certain new provisions, keeping in mind the exigencies of and taking provision of law. However, this would not by itself mean that the procedure which was being the introduction of such changes was incorrect or in contradiction. The legality and correctness of an action has to be judged based on the statutory scheme prevailing at the time it took place, and incorrectness or invalidity cannot be imputed on the basis of subsequent changes in law. Seen thus, the contention of the respondents that Section 110AA of the Act amounts to an admission by the petitioner on the invalidity of the legal position its introduction deserves to be rejected. Therefore, in our considered view, the scheme of Section 17 and 28 of the Act 1962 states that there cannot be a mandatory condition linking the two provisions, and the interpretation of this code of Syed Ali and Canon is patently erroneous. This court in Canon India, while laying much emphasis on the use of the expression, I quote, the proper officer, unquote, observed, Parliament had employed the article the instead of a/n in Section 28 of the Act 1962, so as to give the intention of specifying that the proper officer referred to in Section 28 is the same officer referred to in Section 17. The court further observed that the use of a definite article is indicative of the fact that the proper officer referred to in Section 28 is not any proper officer, the proper officer assigned with the function of assessment under Section 17. However, there is an error apparent in the aforesaid view. Undoubtedly, article the has been used before proper officer with a view to exercise of powers under Section 28 by a specific proper officer and not any proper officer. In the absence of any statutory linkage between sections and 28 of the Act, there was no legal footing for India to hold that the proper officer in section 28 must necessarily be the same proper officer referred to in 17 of the Act 1962. As we have discussed parts of this judgment, the statutory 1962 necessitates that a proper officer specific functions under the Act has been assigned as the proper officer perform such functions by an appropriate notification issued by it is clear, it becomes clear. The officer of customs can only perform the functions the 8 of the Act 1962 if such officer has been designated as officer for the purposes of section 28 by an notification. In the expression the proper officer in the context who has been conferred with the functions of section 28 by conferment under section. In other words, the proper officer is qua the function or power to be decided. Thus, the definite article the in section 28 refers to a proper officer who has been given powers to discharge functions under section 28 by virtue of a notification issued by the competent authority. In other words, the use of article the in section 28 has no apparent relation with the proper officer referred to under section 70. The proper officer under section is said to be determinable only in the sense that he is a proper officer who has been empowered to perform the functions under section 28 by means of a notification issued under section 5 of the Act. In Canon India, this court held that DRI officers did not have the power of issuing show cause notices under sections 28 as they did not fall within the meaning of the expression used in section 28 for the reason that they did not possess the power of assessment under section 17 of the Act 1962. However, as we have discussed earlier, contrary to the aforesaid observation, DRI officers were notified as the proper officer for the purposes of section 17 and 28 of the Act with a notification number 44 of 2011 dated 6/7/2011 issued by the central government. Hence, those officers of DRI who were designated as the proper officer for the purpose of section 28 by the aforesaid competent notices under section 28. Trace on statute law, I quote, the language of statutes is not always that grammarian would use. It must be borne in mind that a statute has two parts. Unquote. It was observed by this court in State versus Gnaneshwar Rao, reported in AIR 1963 Supreme 50, that the aforesaid rule of construction, that the provisions of a statute are to be read together and given effect to, and that it is a to construe a statute harmoniously, has gained general acceptance. In management, SSL Railway Company versus SSRW Union, reported in AIR 1969 Supreme Court 513, this court observed that the principle that literal meaning of the word in a statute is subject to the exception that if such literal sense would give rise to an anomaly, result in something which would defeat the purpose of the Act, a strict grammatical adherence to the words should be avoided as far. The above principles would help us to desist from affording on the definite article the used before the expression proper officer in section 28 of the Act. We have discussed a few other aspects also, highlight Canon India fell in error. A final conclusion. In view of the aforesaid discussion, we conclude that 1. Officers came to be appointed as the officers of customs with number 19 of 90, dated 26/4/1990, issued by the Department of Revenue, Ministry of Finance, Government of India. This notification later came to be superseded by notification number 17 of dated 7th of March 2000, issued by the Department of Revenue, Finance, Government to account for administration. 2. The petition's decision in canon 1. 4 of 99, dated 15th of February 99, the Central Board of New Delhi, which empowered the officers of DRI to issue under Section 28 of the, as well as notification number 44/11, dated July 2011, which assigned the proper officer for 17 and 28 of the Act, respectively. Officers of DRI not brought to the notice of the court proceedings in Canon India. The judgment in Canon India, without looking into the circular referred to above, thereby of the same. 2. The decision in Canon India under the statutory scheme of subsection 34 and 1962 respectively. The decision added the finding that since were not entrusted with the functions of for the purposes of section 28 in accordance with section that did not possess the jurisdiction to issue show cause notices for the recovery of duty under section 28 of the Act 1963. The reliance placed in Canon India on the decision in place for 2 reasons. First, Syed Ali dealt with the case of officers of customs preventive. Decision in Syed Ali were not empowered to issue show cause notices under section 1962, unlike the officers of DRI. Secondly, the decision in Syed Ali took into consideration section Act 1962 prior to its amendment by the Finance Act 2011. However, the assessment in respect of which the show cause notices under challenge in Canon India were passed under section 17 of the Act as amended by the Finance Act 2011. 3. This court in Canon judgment on 2 grounds. 1. The show cause notices issued by the DRI officers were invalid for want of jurisdiction. Show cause notices were issued after the expiry of the prescribed limitation period. Present judgment, we have only considered and reviewed in Canon India to the extent that it pertains to the first ground, that is, the jurisdiction of the DRI officers to issue show cause notices under section 28. We clarify that the observations made by this court in Canon India on the aspect of limitation have nor reviewed. Thus, this decision will not disturb the findings of this court in Canon India insofar as the issue of limitation is concerned. 4. The Delhi impacts observe that section 28, subsection 11 could not be said to have cured the defect pointed out in Syed Ali, as the possibility of chaos and confusion subsist. Production of the said section with retrospective effect. In view of this, the High Court declined to give retrospective operation to section 28(11) 8 of April 2011 by harmoniously construing it with explanation 2 to section 28 of 62. This was the main plank of your submission. We are of the concept that the decision in Mangli impacts failed on the policy being followed by the Customs Department since 1999, which provides for the exclusion of jurisdiction of all other proper officers once a show cause notice by a particular proper officer is issued. It could be said that provides a sufficient safeguard against the apprehension of the issuance of multiple show cause notices to the same as Section 28 of the Act. Further, not have applied the doctrine of harmonious construction to harmonize 2811 with explanation 2, because Section 2811 and explanation 2 operate in two distinct and no inherent contradiction between the two. Therefore, we set aside the decision in Mangling Pax and approve the view taken by Bombay in the case of Sunil Gupta. Section 97 of the Finance Act 2022, which inter alia retrospectively validated all show cause notices under Section 28 of the Act, to be unconstitutional. It cannot be said that Section 97 cured the defect pointed out in Canon India, nor is it manifestly arbitrary, proportionate, and overbroad. Recorded in the foregoing parts of this judgment, we clarify that the findings in respect of the vires of the Finance Act 2022 is confined only to the questions raised in the petition seeking in Canon India. The challenge to the Finance Act 2022 on grounds other than those, if any, are kept open. Subject to the observations made in this judgment, the officers of Directorate of Revenue Intelligence, Customs Preventive, Directorate General of Central Excise Intelligence, and Commissionerates of Central Excise and other related officers are proper officers for the purposes of Section 28 and are competent to issue show cause notice thereunder. Therefore, any challenge made of such show cause notices issued by this particular class of officers on the ground of want of jurisdiction for not being the proper before various forums, including this court, shall now be dealt with in the following manner. A. Where the show cause notices issued under Section Act 1962 have been challenged directly by way of a writ petition, the respective High Court shall dispose of such writ in accordance with the observations made in this judgment, such notices for adjudication by the proper officer under Section 28. B. Where the writ petitions have been disposed of by the respective High Court and appeals have been preferred against such officers before this court, they shall be disposed of in accordance with this decision, and the show cause notices impugned therein shall be adjudication by the proper officer under Section 28. C. Where the orders in original passed by the adjudicating authority have been challenged before the High Courts on the ground of maintainability due to lack of proper officer to issue show cause notices, the respective High Court shall grant 8 weeks' time to the respective SSC to appeal before the Excise and Service Tax Appellate Tribunal, that is the SISTAT. E. Where the writ petitions have been disposed of by the High Court and appeals have been preferred against them, which are pending before this court, disposed of in accordance with this decision, and this court shall grant 8 weeks' time to the respective SSC to prefer appropriate appeals before the SISTAT. High Court on the ground of maintainability of jurisdiction of the proper officer to issue show cause notices, this court or the respective High Court shall dispose of such appeals in accordance with the ruling in this judgment and restore such notices to the SISTAT for hearing the matter on merits. Where appeals against the orders in original involving issues pertaining to the jurisdiction of the proper officer to issue show cause notices under Section 28 are pending before the SISTAT, they shall now be decided in accordance with the observations made in this decision. In view of the aforesaid, we allow the review petition number 400 of 2021, titled Commissioner of Customs versus Measures Canon India Limited, and the connected review petition numbers 401, 402, and 403 of 2021 respectively, insofar as the issue of jurisdiction of the proper officer to issue show cause notice under Section 28 is concerned. As discussed, the findings of this court in Canon India in respect of the show cause notices having been issued beyond the limitation period remain understood. We set aside the decision of the High Court of Delhi rendered in the case of Mangli impacts and uphold the view taken by the High Court of Bombay in the case of Sunil Gupta. We also uphold the constitutional validity of Section 97 of the Finance Act 2022.
Extremely obliging.
May I request,
My lords.
we request Mr. Lakshmi Kumaran to be unmuted. He has made a request
Yes.
to be unmuted. Yes.
My lord, extremely
Yes,
grateful.
Kumar.
Only thing, my lord, the matter, actually the Canon Nikon matters, which my lords have just now disposed of, these matters have to be remanded to the tribunal for their decision on merits, because some portion within the time limit, and therefore that has to be sent to them, because all the remand, this particular portion probably was missing. So I request my lord to remand those matters.
Mr. Venkatam, the court masters that will be
Yes.
Paragraph on this.
Because this dispute started in, and I had the privilege of appearing before His Lordship since better culmination.
Lakshmi Narayanan, Ms. Saranya, and her team, you, Mr. Venkatraman, but for your able assistance, it's difficult to decide these complex issues.
So we have concluded Tola and we have concluded Canon, and Canon.
Dispute syntax.
With my lord's kind leave, minutes, item 102,
Yes.
I'm afraid, minutes, it hasn't issued. When the notice was issued, it's been mentioned post after the decision in review.
Covered by that. Yes.
We have decided.
It's minutes, as far as 102, that may have, that's to be heard because that's the dispute concerns SEZ.
They are relying on Canon. But he's mentioned it last
No,
time.
minutes, it is, in fact, my lords indicated on the last occasion, await the outcome and then mention so that that could be taken a decision on. Minutes here, completely unconnected. And the issue is minutes 102 minutes. The issue is minutes whether SEZ Act of Customs Act applies, not with regard to proper office.
We showed it on the last paragraph.
Minutes, my lords may kindly come if at all minutes, para 35. The Honorable High Court has said that it's also been
Judgment now. We have delivered
minutes, my lords may kindly say on 16-1. If I have a minutes, on 16-1-2023 notice was given. That day it was said the outcome and then post after. And I'm afraid.
Please, Your Lordships.
Yes, if I may mention.
Yes.
Milord, I'm sorry, Milord. Milord, I want to mention this matter. I did earlier. This was a matter, Milord, that Milord, this was a whole batch of matters. I think Your Lordship had marked it to a coordinate bench order. When the matter came up before the coordinate bench, Milords, the court requested me to re-mention the matter before this court. Milords, when the matter came up,
But the matter was detacked at your place.
correct. Milords, when the matter, let me finish. Milords, when the matter was detacked, it was marked to another court. Milords, that's what I'm saying.
Yes.
When the matter came up day before yesterday, Milords,
Before that bench.
that bench, that because this issue is pending in a number of matters which is listed today before your court, Milords, please see the order of the coordinate bench. They said please request number 1 if this matter. That's why, Milords, I'm mentioning it, or I would not have. Your Lordships, this happened in court. Yes. Please, Milords,
One second. Orders, observe some order. We go from left to right. We're not going to allow anybody to just jump up and mention like this.
Yes, Milords.
And he's on his legs.
The court directed me, Milords, to make a request before.
I'll just look at it. I'll look at the order and we'll take a.
My lord, SLP of bail, my lord. Bench had dealt with the case of a co-accused.
Sure.
All right, you send your email. I'll look at
Yesterday's matter, that family dispute about a restaurant, the Lordships permitted us to come back after seeing the order, but both the count
on the modalities or on the. All right, just sure.
We have agreed on the valuator, my lords.
signed by both the parties, both the council.
My lords, there are. So we've dictated the order now, my lords.
May have to be made. These are agreed by both sides.
All right, let's just see 1 second. We'll look at the order.
Yes.
Which part of the order, Mr.
Madam,
Reddy?
in para, madam, this name has come. Anandam and Company Chartered Accountants has been agreed. This is, madam, my first suggestion goes. 9 matters.
During the course of the hearing, just read the whole para. It has been agreed that in order to resolve the disputes between the parties, fine valuer may be appointed so that the business of the partnership can be valued inclusive of all its liabilities.
Yes. So Anandam and Company has come. That's agreed.
Once the net current valuation is agreed, the petitioner shall have the first right to take over the first respondent, to take over the an account name, to take over the share of the first,
To take over the share.
equivalent, an account will to take over the share of the first. We'll say equivalent to our share will be of 14% in the partnership with the date of the valuation.
My lords, we request my lord to make it 4 weeks. We have
But in para 11,
yeah,
my lord, the expression that has come is, my lord, the sole asset of the partnership firm.
and the implementation, the first petitioner shall act as the receiver of the business and affairs of the partnership in the restaurant. Yes.
But in para 11, praying, my lord, that this is the sole business of the partnership firm. Assets are many. They are
Which is the sole business.
Yeah. Those words, assets belonging to the business, may have to go.
Which is the sole business of the partnership.
Yes. But in para 9,
yeah,
expression that is used is, my lord, valuation.
Valuation.
Yes.
Maybe also the valued inclusive
On once a net current valuation is arrived.
Yeah, that accepted that.
Yes, madam.
And anything else?
Pray, my lord, that the valuation that has to be completed, your lordships have indicated 31st.
Para 11.
Yes, madam. We have till 31st January.
January 2025. Para 11.
para 12 and 13.
Yes.
Lord, para 12. To the petitioners to deposit a before the High Court of Telangana, reckoned as refundable security deposit deposited before the High Court of Telangana. We said no problem.
My lords. 13, my lord.
Refundable, we'll say
security deposit.
A fixed deposit.
Security deposit.
In an interest bearing account.
It shall be invested in.
My lord, last.
Yes.
My lord, lastly, in a little above para 13, 4 weeks, 2.5 crores shall be deposited within
4 weeks thereafter.
That's all. My lord, we have a evaluator Anandam and Company, which was.
If there's any typographical order, but these corrections are now final.
We've also filed a joint memo where guidance your lordships are correcting. But
all right.
My last permission. May I mention a matter? This is a matter where we had moved from a certain direction So now all we really want to do is withdraw.
All right, we can list
Only for the purpose.
withdrawal.
With client permission, number 4646424. Two different.
Yes,
May I have my lord's leave to mention SLP of Rajasthan, my lords? This is from my lords. The background is that district DIAs, district assessment committees, were my lords disbanded. My lords, it needs to be heard today, my lords. 20,000 mines in Rajasthan, otherwise is banned. So SIA, that state, all of the.
When is the impugned order passed?
My lords, passed. This is of August 2 days back. For extension of time, that otherwise if MOEF would have been given some pending applications, so my lords, that is kindly considered, and that application has only on 4th of November. This needs to be heard. There are two more SLPs by two other states.
Give the number.
Related, but we'll give again.
Yes.
Plus there's SLP Malats on behalf of Union of India Malats.
Yes.
These are Malats, two contempt orders. High Court Malats in a matter where compliance is already there. Would your lordship consider that also for tomorrow?
Yes.
I will just give the details, Malats. I'll give the details.
Malats,
there's a joint me and my colleague. This is a pending SLP. Us to find a cure for the elderly couple whose son was suffering from that. He was.
Oh yes.
We find, if your lordships would like to take that up and give home care to the to him, my lords, the satisfaction
for tomorrow.
As convenient to my lords, my lords. I
can take it up because I remember.
Have found a solution, and that can come into force as soon as the order is.
Tomorrow, so that we can then dispose it.
I'm very grateful.
And the parents have also been.
Discussion, my lords. We did joint inspection.
Thank you, Ms. Bhatt. We request. We'll keep it tomorrow so that we can dispose.
I'm grateful.
Yes, आपके पास है ना number?
One mention with regards to the matter that my learning. The only issue is that para 140 specifically says that all across the country, pan India will be stopped from today, 7th of November. Therefore, that's the only reason.
To midnight. We'll keep it in the morning tomorrow. Yeah.
I'm also appearing in.
Yes.
One application 38245 filed by the Arun Hublikar. Sir, I want to petition in person.
Yes, he has come here repeatedly. It was decided before, right?
Yes.
He had sent the matter there.
Yes.
Now everything has come to an end there.
Okay.
What did you say?
Passed an order on 8th of April.
Now finally I got you up. Yes.
Please, your lordships, this is the vulnerable. Your lordships had passed directions where uniform guidelines
adopted by all High Courts, Your Lordships. And those were circulated, courts have adopted them. Courts have come into force, Your Lordships. Those references have been changed by Justice Geeta Mittal. So our Lordships is to make a direction, otherwise we from every High Court.
What today?
Your Lordships, only that the new and updated model guidelines which have been given in report dated 25th October adopted by all the High Courts.
Justice Geeta Mittal, chairperson of the committee constituted by this court, has sought a clarificatory direction of this court, direction from this court to the effect that the model guidelines.
Yes, Your Lordship. Model guidelines.
Dated model guidelines by the chairperson on
report dated 25th.
By her report dated 25 October 2,
Please.
may be circulated to all the High Courts.
24.
2020.
Right.
Permission is granted in terms of the High Courts
within 4 weeks.
shall as updated guidelines within a period of from the date of communication to each.
We would like to set the clock back, but unfortunately, it's very grateful.
Thank you. Item 2.
This is the great Malads. Your Lordships have got one respect to Rajasthan. Gujarat has not been able to visit Malads, so they will visit, and after Your Lordships, in even independent Malads, in dissent Malads, and otherwise, the Lordships like to look at it. I can take Your Lordships through the key recommendations.
So Rajasthan, the reports. So we can accept the report.
There is a dissent, Malads. They filed.
To be said on this, it's going to take some time because they, for example, contrary to judgments of this court, they have said. So I mean that's very serious.
Malads,
recommended. Every party has. This expert committee says no to diverters.
What this expert committee says on 50% diverters are already installed. Efficacious study of it. So
anyway, if my learned friend is defending diverters, that's all right.
To carry out an efficient only, Malads, it's a huge amount of huge quantum of money, Malads, and that every now and then. So there's no point in. There are objections. I will have to take of the committee at length. The committee, in our opinion, has carried out enhanced some of the priority area and directed corridors to be created of the existing Malads, that there is a corridor at the bottom and they suggested one at the top to look at, and experts have been directed from the Forest Department, Wildlife Institute, from the Central Electricity Authority for the technical aspect. Wildlife is one aspect and how it fits with technologies another. So these corridors, that this entire area, and just first IVF chick also born, Malads, of the Great Indian Bustards. Efforts also this committee has looked at and given comprehensive direction, Malads, really to balance out. But there are objections. I bow down to my colleagues. Object. We will have to take Your Lordships through the.
After a week or so, then.
Yes, you may keep it after a week. Subject to what the ASG says and what your we could request for the report on Gujarat if it's coming. This report is of September.
To be done.
Gujarat report may take.
This may take 6 weeks.
All right, then you may keep it place. I mean, what?
And Rajasthan together then.
As my Lords deem appropriate, we'll.
But then the committee to complete in 4 weeks.
Aishwarya Bhatti states that while the expert committee appointed by this court has tasked in relation to the state of Rajasthan, the committee is the state of Gujarat and submit a report which is stop. Mr. Sham Diwan, Learned Senior Counsel, appearing on behalf, states that the petition submissions to make in regard to the modalities suggested in regard to the state of Rajasthan. Full stop. it is accepted on both sides that it should be desirable that the report is taken up together with this report which has been submitted. Full stop. Presently, we direct that the proceedings be listed on after 6 weeks. The committee shall carry out its work in relation to the state of Gujarat. In the meantime,
which may be made available to all parties.
The report of the committee shall be made available to all parties.
Would your lordship consider 8 to January?
It will say 8 weeks. No difficulties.
2 points, Your Lordship. Solar power developers. Your Lordship, now, despite the fact, as well as the committee saying that the restrictions on lines, approvals have not been forthcoming, saying that due to the. So that Your Lordship may clarify that.
There can't be approvals just now. It's a middle.
Take it up after.
Yeah, exactly.
My lord's earlier judgment clarifies my lord's comprehensively. Now, recommended these further recommendations, but whatever lordship's judgment,
right,
my lord,
by us in our judgment should not be
as such. Your Lordship permit anything one way or the other. But anyway, there's no need for
a instead of. Okay.
Please, ma'am.
I mean, except where we had anticipated the report of the taking.
Your Lordship said you
but wherever we had our judgment permits whatever, then you need not await elections.
I bow down because my lord's already 80,000 square kilometers. Now this committee has taken the priority area from 13,000 to 14,000. That's what they have said with regard to Rajasthan. They'll complete the work for Gujarat also.
Second, Your Lordship, there's also the projects with the lack of approval. So Your Lordship may say the project may be considered by the authority.
Why don't you take out some small application next time? We'll grant that extension, there's no difficulty.
What all these gentlemen.
But let them take out an application. Today we'll
disclose as to what the funding is. They come in the final.
Of passing an order. We'll consider it. Ms. Bhatti will also have an opportunity to deal with this.
Relax. Grateful.
Is the application
yes.
My lords will recall yesterday I mentioned this application that the NCRB's exercise of data collection will not be hindered direction regarding removal of reference to caste in the registers.
I agree, my lords. That may be necessary.
We'll clarify that. I mean, excellence.
Very well. That's the prayer.
Just say that but NCRB should move. Why should we do that at the behest of the petition?
Also taken instructions from MHA on this, my lords.
All right.
We have no objection. I've been doing this.
The miscellaneous application a clarification has been sought in the miscellaneous effect in the judgment of this court dated shall not impact the collection of data by NCRB, by the National Crime Records Bureau, into brackets NCRB. Bhatti, we are full stop. Ms. That half of the petitioner submits that such a clarification may be issued so as not to impede the Ms. Aishwarya Bhatti, then an ASG, submits that instructions from the Ministry of Union Ministry of Home Affairs to the effect that such a by this court. So, therefore, to the generality of the directions or their implementation, as issued by this court, it is clarified that direction 4 collection of data by the NCR.
3rd October, that's not 31st.
3 October, not 31st October.
Seek your lordship's indulgence. We are being led by London SG. If your lordship could do, my lord. Lord, this is that matter wherein we have
36 SLP has been pending. Just a minute. Yes. And section 9. Now, my lord, they don't even move a 37. And an SLP here. In section 9. After the award, they don't file a section 37, but an SLP against issuance of section 36, where no application deposit is made.
Now, this order is concerned. Let's see.
Which one is on the section 9?
9.
Yes. The overbearing consideration of pleadings that this is a company has a net base, asset base of net worth of over 9,000 crores. So what is the case that you made out? Explain to your lordships how these highways function.
Let the SG.
No, I have no. Since your lordships put a question, I answered. I have no difficulty. I'll be here to assist your lordships.
an award has been virtually 9.
No.
Anyway, we'll take it up. You tell us.
2 o'clock.
Would it be today or Monday or Friday, whatever I might say.
Spare 5 minutes.
Take it if you want to, or we can take it up
tomorrow. It's very great.
Yes.
Great.
About can I take 5 minutes or should we watch it? Because we have been waiting.
The two candidates.
Exactly, because my lord, the Chief Justice intervened.
We'll take it up at 2 o'clock.
Take it up at 2 o'clock.
We'll
Before the.
Yes.
Great.
Though they have been selected to the judicial service.
They have been selected.
They have been selected.
And because I'm just seeking as I might have some guidelines.
They're both visually challenged. No?
Yes, it does. Imagine if others had got in, what would have been? So I was seeking some directions which can be followed all over the country. I formulated something. In fact, I told Mr. Rambach. I in fact requested that because it's ongoing recruitment, but for future. Two directions I was seeking.
All right, we'll come back.
2 o'clock.
Mr. Ramachandran is in some difficulty.
I have also filed my written submission.